Well, the family court drama, chaos and crisis just doesn't stop. As you will all know, over the last 2 years I have been calling for the President of the Family Court, Sir Andrew McFarlane, aka Mr. Dressy Uppy himself, to come out from under his wig and ridiculous dressing gown to try and show some leadership by talking directly to us, the people, the family court service users, in order to explain the madness of the family court. Well, blow me down. He recently popped up on a BBC Radio 4 Broadcasting House interview, and as I listened to it, what I was praying for was that he was going to finally try and reach out to win hearts and minds, to provide reassurance, direction and even an apology for the broken, inept, incompetent and incomprehensible family court system. So, how did he do? But before I give my thoughts, let me run my excellent introduction. I am Philip Kedge, a retired Police Chief Inspector and Director of the Mckenzie Friend UK Network. I have been a Mckenzie friend for over a decade and am the founder of the national campaign of #LikeNotHate. In all my vlogs, my views and opinions are entirely my own. In relation to the topic of the vlog, the BBC Radio interview with Sir Andrew, you can hear it in full by clicking on the link to the BBC in the description box, and you can make your own minds up. Well, I made my mind up, and in summary of my thoughts, no apology, no mention of any failings by the family court itself, no criticism of its own processes and procedures, no understanding of the irreparable harm being caused to the little people, the children, by the failings of the courts, and to cap it off, you'll choke when you hear this, wait for it, from my interpretation of his comments, he actually blames us, the public, the service users, for causing the carnage within his beloved family court. It's all our fault. What kind of institutionalised, self-serving, self-indulgent, arrogant position is that? Unbelievable. Let's have a listen to the first audio clip and then unpack it.
Some of the people who come to court, particularly to discuss disputes about their children, would be better served not coming to court. We're seen at the moment as the first port of call, but we should be the last resort for them where there aren't issues of domestic abuse or protection or safeguarding.
So if we split up separating couples into those that have safety issues, domestic abuse and abuse cases, and with respect to everyone listening, we're not going to talk about them, we're going to talk about cooperative systems. How many couples come to court who could settle outside or not using court?
Well, there's no bright line between those two groups, but my feel is that about 20% of the families who come to court to have a dispute about their children resolved would be better served by at least first of all trying to sort it out themselves in other ways.
Now, on the face of it, listening to it passively, you may think it all sounds reasonable. But wait, when you really think about it, I suggest that it's a total utter nonsense that detracts from the real issues and ignores the very large elephant in the room. Let me explain. What Sir Andrew says is that 20% of family court cases should not be in the family court because they don't have any domestic abuse, safeguarding or protection issues. Well, by adopting his strategy of trying to divert 20% away from the family court, he totally misses the point, and it is clear that Sir Andrew, with all of his out-of-touch, lawyerly intellect, is ignoring the real issues that us, the people, understand and what thousands of you may be experiencing. If you turn his own statistics on its head, That means that 80% of cases have allegations of domestic abuse and safeguarding concerns. 80%. Now, how many of those allegations are nothing more than spurious allegations based on hate, hurt feelings, irrational anxieties, and unfettered emotions, which his judges are failing to get a grip on? In my estimation, between 70 to 80% of allegations made to the family court are nothing more than spurious, irrelevant, and often totally ridiculous allegations based on relationship incidents and behaviours, which of course may be unfortunate and regrettable, but do commonly and even understandably happen in most relationships at some point. Spurious allegations and sound bites of abuse and coercive control, which risk-adverse judges from Planet Stupid are allowing to be escalated out of all proportion and turning them into long drawn-out fact-finding hearings where relationships between children and the resident parent, who are mostly fathers, are being systematically destroyed. Let's listen to this next clip.
I'm just wondering how much frustration there is, because you've been involved in various reviews going back, to the year 2000, and the Children Act came in 1989, and the Family Solutions Group, which reported in 2020, said the family justice system is in crisis. The numbers of parents making applications are unmanageable, and family courts are stretched beyond limits.
That's accurate, I'm afraid. We have a
the
very
family
high
justice
volume
system
of
is in crisis.
crisis is not a word I'd use, but where our resources are fully stretched and we're unable to get to cases in a timely way, and delay itself is not helping.
Let me help Sir Andrew understand why the system is indeed in crisis. It's not simply because too many people are using it, it is at the system itself where the processes and procedures are totally flawed. In fact, it is so fundamentally flawed that any vengeful, spiteful and hateful resident parent can easily use what I have called the blueprint of hate to manipulate and weaponise the family court itself against the non-resident parent to restrict, reduce, minimise or deny child contact. And this is what I observe as being endemic in every family court up and down the country. It's a terrifying situation, and if you want to find out more about that, then please watch my vlog called Why the Family Court is So Terrifying, The Blueprint of Hate. Probably the most important family court vlog you should ever watch. But now listen to this. This is very interesting. The interviewer asked Sir Andrew if part of the problem is whether the public sees the court process as a legal issue when it is not.
So do you think they see it as a legal issue when it's not a legal issue?
Yes, and in the end, Paddy, it's not a legal issue. It's a relationship problem that they have, and the law provides a structure that, if they need to, will resolve the dispute and impose a resolution upon them.
Well, of course he's right, and I have been saying that for the last 10 years. It's not a legal issue, and that's why you don't need lawyers in the family court. Lawyers can't get you what you want, and to make an analogy, they are no more useful than coaches at a football match being paid to shout at the referee when the referee is going to apply the rules and make their own minds up. Judges are going to impose their solution, looking at the case from the perspective of the child and applying the welfare checklist. And it is of total irrelevance as to whether you have a lawyer or not. So, stop handing over thousands, if not tens of thousands of pounds to lawyers. You would be better off putting that money on a bonfire, at least it will generate some heat. But better still, engage your brain and invest it for your children's futures. Stop the madness of handing over money to lawyers. So Sir Andrew and I do have something in common. However, he then bottles it because he fails to go that extra step to actually denounce the sick in the head family lawyers who all too often pit parents against each other in hate and acrimony for financial gain, engage in thousands of pounds of totally unnecessary work, who leave people in crippling financial debt and have absolutely no professional duty of care to any child. How abhorrent and disgraceful is that? These lawyers are a central and significant part of the problem, and any solution will only work if we stop hiring them and to get rid of them for good. You see, how does Sir Andrew think he can actually divert people away from the family court when there is a £2 billion a year industry whose very existence is dependent on conflict and acrimony, and whose business plans are invariably predicated on diverting people away from mediation, away from a solutions-based approach, and into the madness of the adversarial family court system, where obscene amounts of money are fleeced off parents who are daft enough to pay them. We have an entire family law industry that exists in a field which isn't even based on legal issues, who can only exist by encouraging conflict and acrimony, and which has no duty of care to any child. And these people are allowed inside the family court. Absolute genius. Sir Andrew, you need to raise your game and start getting a firm grip on that one. So, on to the next audio clip. I wonder, what are the other radical strategies Mr. Dressy-Uppy has to reform our family courts?
And once they get to court, is the language and the adversarial system weaponising the things that lead them to separate?
I fear it is, and this is a realisation that's crept up on us over the years. You thinking back, you're a young man, but you may remember the phrases custody and access. Well, those went out when the Children Act came in 30 years ago, but they're still used. People talk about a custody battle, a custody fight.
But do you think that the language could be changed and should be changed?
Yes, I think it should. I think we still are. Listeners will be familiar with the film Kramer v. Kramer. Well, the court cases are still listed as Smith against Smith or whatever it is. And barristers talk about my opponent, or someone is the applicant and someone is the respondent. And we have hearings which are called dispute resolution hearings, where we should be just problem solving for the future of the child.
Oh, I see a pattern of behaviour emerging. To blame us yet again, the stupid people. This time for using language such as custody and access, and my child rather than our child. And his dynamic plan for reform is to try and change the language of the parties being called applicant and respondent, and where the court lists cases in an adversarial way such as Smith versus Smith. Well, language is of course important, but any idea that suddenly changing the language is going to make any significant difference in isolation is laughable. Imagine this. If you are faced with a vengeful, hateful and spiteful resident parent who are mostly mothers, just remind them that it's our child and it is not you versus me, and the penny should drop. You can expect a big parental love-in, and both of you, in the spirit of positive co-parenting, can now exit the family court and sort it all out with forgiveness, laughs and smiles at mediation. I rather fear that Sir Andrew may be a little deluded. The crisis in the family court is a little bit bigger than that. So let's move on to his last big strategic plan, which in the spirit of balance, proportionality and fairness is perhaps his most credible and widely supported one. Let's listen to the next audio clip.
Are you too clouded in secrecy for very good reason for protecting the identity of children? Are the procedures of the family division too opaque?
Well, I think that what the family court does on behalf of society is very important, and I think society, generally, individuals need to know more about what we do.
And do you think that journalists steer clear of your courts for fear of contempt of court because of the reporting restrictions against identifying children?
They do, and I think if I was a journalist, I would be very careful at the moment about reporting family cases, because the law of contempt does engage with what goes on at a private hearing, and part of the proposals I've made is to clarify that and reassure journalists as to what they can do and what they can't do. In short terms, journalists would be able to come into court and be able to report what they see and hear without naming any of the people involved. So they're shedding a light on what we do, but not who we're working with.
Enabling the free press to report from within the family court is long overdue. I can't wait, because when the press understands what actually goes on, the types of spurious allegations that are being made, and the mismanagement of these allegations by risk-adverse judges, minimising and denying contact between the mostly fathers and children for months and months on end, destroying childhoods and relationships, the lid will come off. It is my hope that through the media, once and for all, the family court will be exposed for the broken, inept, incompetent and incomprehensible system that it is, and that will drive widespread reforms far beyond the sticking plaster approach and the schoolboy level of thinking of Sir Andrew McFarlane in blaming us, the service users. Indeed, I am already applying for my independent press pass to be the first in the queue. So, I'm nearly done, but there is one more issue that I must bring to the table on behalf of all of us, the people, the service users. As Sir Andrew heads into the history books as perhaps one of the most ineffective, shallow-thinking family court presidents in its history, where chaos, crisis and destruction of child relationships with mostly fathers reigns, we need to call for a change to the system starting at the very top. We need to disconnect the appointment of the president of the family court division being handed down to another lawyer. What we need in that position is an independent leader, a leader who reflects not the institutionalised inward thinking, outward blaming, self-serving, out of touch judiciary, but a leader who represents the needs and indeed modern needs of us, the people. An independent leader to drive through real change, real reform, to end the inexcusable institutionalised mentalities and thinking that Sir Andrew McFarlane himself seems to hold. The cycle of self-cloning, the head of the family court, must be broken for reform to happen. And as for you, the people, the service user, I am confident that you are on my side. You understand what I am saying in bringing about real change with proper, dynamic and intelligent leadership. Thank you for listening. Until next time, stay strong.